Ms. Latulis, in cause number 25, DCCR 0850, you're charged with the second-degree felony offense of abandoning or endangering a child from May 30th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they charged you with? And then in cause number 25, DCCR 0851, you're also charged with the second-degree felony offense of abandoning or endangering a child from May 30th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for 5-year deferred probations. There would be $500 fines in each case, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or a denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Latulis is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. What is the current status with regard to contact with children?
I am.
You have them?
Yes, ma'am.
It wasn't a condition of your bond that you not have them?
The ones that I have, I don't have the other ones that I got shortly on Colin and grandbaby.
What's the status with those two?
They're not with me.
So what children do you have with you?
My other boy.
Was CPS involved?
It's on. They close it Friday.
They closed it Friday. What was their finding?
They
Stand up. Speak up.
they just closed it. I went through parents and I did everything I had to do.
You did go through parenting classes? Just a second. Did you take regular drug tests with them? Did you pass all of them, or do you have any issues?
No matter.
You passed them all?
That's all.
So where do you and your, I'm printing that out. Where do you and your children live now, the ones that you have?
This kind of Spencer Drive. Walmart. It's here.
So where are these two?
That's one of them is my grandbaby. She with her mama, and my other son, he's with my grandma.
Okay, so it is still a condition of your bond until sentencing. I'll look at more information then, that you are not allowed to have these two children.
That's fine.
Okay, all right, so you need to stop on your way out today and talk to probation before you leave the courtroom. And she's sitting at that desk right over there, and then we'll see you back at sentencing.
Thank you, Judge.
Thank you, Your Honor.
Mr. Rojas, you have Deshaun Robertson. Good morning. Are you Deshaun Robertson? And Ms. Robertson is charged with aggravated assault with a deadly weapon and cause number 25 DCCR 0914. And what is the announcement?
Judge, if we can get one more announcement document, Ms. Robertson wants to give me some medical information, and I still need time to go over the videos with her.
Okay. Any issue, Mr. Nichols?
Nothing that I'm aware of, Your Honor.
All right, so Mr. Robertson, I'm going to reset your case one more time. Make sure you make an appointment, go visit with Mr. Rojas, get him anything you intend to so he can get that to Mr. Nichols, and we'll get an announcement at the next court date. All right, you're free to go.
Thank you, Judge.
Let's see. Mr. Lewis and Mr. Price on, the expunction, 25 DCCV 2044, Quentin Derry. Mr. Lewis has filed a petition for expunction. The response, the state filed is that it looks like his argument is in cause number 2240142 and 2240143. Those two offenses, the petitioner pled guilty to a lesser offense and therefore had a conviction for something lesser, took responsibility, cause numbers. Okay, and he served court-ordered supervision on those two offenses. Mr. Lewis, what is your position?
Well, Judge, these two cases were dismissed prior to a refiling of a misdemeanor case down in County Court number 3. Later on in that case, of course, Mr. Derry did plead to a deferred adjudication. Over there, we served a 1-year deferred, I believe it was. He, of course, does not have any conviction or anything as related to, of course, these cases or even that case there. And as well as, it was my understanding and looking at the code that the straight probation and the deferred was looked at differently. And so my position, of course, is that since he's going to defer there, he still should be eligible for expunction here. And as well as, like I said, though, that wasn't in conjunction with the plea done at that time. Like I said, he was both cases he was dismissed, and then we went down to County Court 3 a little bit later.
I guess, Mr. Price, in your response, you are citing, hold on a second, I just thought I wanted to clarify. So these were deferred probations.
Correct. Well, those two charges, the felony charges, were dismissed.
Right.
And he pled to the misdemeanor charge and received deferred adjudication.
So I guess I'm confused because, and maybe I'm not reading this all the way through carefully, but part of your response talks about the Court of Criminal Appeals saying in certain situations, deferred adjudication, does constitute a final conviction. Do not locate a case directly on point to the expunction in the present case. And so my understanding is that even if it's a reduction, if there's any responsibility taken for the offense, even if it's a deferred or to a lesser offense, that they're not entitled to an expunction, but could be potentially entitled to non-disclosure because of that deferred.
And my question with that, just like I said, these were two cases, a sexual assault and an assault family member
Mhm.
case. Both cases were dismissed. So then my question would be, will that go to both cases here or just to the assault family member children?
Would be all three cases. The two felonies and the misdemeanor would all be entitled to non-disclosure.
Mhm. I think so too.
Okay.
And and I'm looking just for the record, I'll take judicial notice of the court's file. It does include the motion to dismiss in those offenses, which specifically stated that he was convicted in another cause. Even though he wasn't convicted, the way I read that is he took responsibility for a lesser.
When that was filed, I did take that up with Ms. Mofino, but at that time, of course, it had already been filed and signed.
Right.
So not much we could do about it.
No, and it should have said did something, but
Right.
maybe not convicted, even though he
Right.
took, but the law in the expunction law is pretty clear that if you take responsibility, even in a deferred, so I'm going to deny the petition in this cause. I think at the appropriate time, a non-disclosure would be appropriate though, in all three.
No, three.
Yeah.
Yeah, I guess the other question with that would be that needs to be directed for those, of course, the two felony cases here, and then the second one down the hall.
They all get filed in the same.
They all get sent. Yeah, I'll take care of all of them. Yeah. All right. Thanks.
No problem, Jeff.
I need to order denying on that one.
Yes, ma'am.
Have we seen Mr. Adams? Mr. Adams? Let's see. Ms. Holmes, do you have Derek Mouton?
Yes, Your Honor.
Do you have paperwork on any?
I don't have any paperwork.
Good morning, sir. Are you Derek Mouton?
Yes, ma'am.
And this is 25 DCCR 0748. Mr. Mouton's charged with assault on a peace officer. And what is the announcement?
Yes, Your Honor. This is our first setting. I have had discussions with the prosecutor. I believe we will be able to get this resolved next setting if we could have one more reset.
Sure. It looks like you just got on about a month ago.
Yes,
or so.
ma'am.
Okay. Any issues?
No, Your Honor, I think we may have it closer worked out.
All right. I will reset it one more time. Mr. Mouton, make sure you stay in touch with Ms. Holmes so you guys can visit about your case before that next court date, and we'll get an announcement then.
Yes,
You're free to go. I don't know why it looks like that. I hit something, I'm sure. Mr. Kelly, you've got Jeremy Chapman.
He's present here.
Morning. Morning, Mr. Hawkeye. Welcome back. Good morning. Are you Jeremy Chapman? And Mr. Chapman, this is charged with solicitation of prostitution in cause number 25 DCCR 1337. And what is the announcement?
Yes, Your Honor. We have one more announcement, please. I think we'll get to a resolution. Mr. Hoffbauer, I've been discussing it. Yeah. Overly complicated. I've discussed some things I need to get to.
Sure. Any issue? Mr. Chapman, I'm going to reset your case. Make sure you stay in touch with Mr. Kelly so you guys can visit before that next court date, and we'll see if we can get an announcement then. You're free to go. Thank you.